Welcome to the recorded lecture for Florida Survey of Law about professional ethics. Professional ethics is a topic that is always tested on the Florida bar in the essay section. And these tests, these essay questions appear almost always in conjunction with other topical questions. So it's usually an add-on to one of the essays or sometimes several of the essays. So you have to look for the ethical question in the call of the question and remember that you have to deal with that ethical question in addition to the other topic. The Florida Bar examiners will have identified the particular rules of professional conduct that are covered on the bar exam, and they're here on this slide. Basically, we're looking at Chapter 4 of the Rules of Professional Conduct related to attorney-client relationships and transactions that we do as an attorney representing clients, and also Chapter 5 relating to trust accounts. This particular slide identifies, this one and several additional slides identify some examples of the ethical issues that have been part of questions on the bar exam in the past. So, for instance, questions about whether it's possible to represent a friend in a civil litigation when you as an attorney might actually be called as a witness to testify, or things like how you have to deal with parties in litigation that are unrepresented, or concerns about commingling funds. These are additional questions. We've actually gone through and culled the ethical questions from the bar exam to identify the types of questions that have been addressed. So if you're looking for practice, see if you can go through these couple of slides. There's one more, to identify what rules are triggered when you see a question like this and what your responses might be. These are examples of questions that have happened in the past, and you want to potentially test yourself when you are trying to figure out if you have covered all of the ethical issues. So I want to talk about the potential rules that are subject to being tested on the Florida bar. And you'll see on these slides that a lot of the information is really just the statement of the rule. And we'll address that in as much detail as possible. Sometimes it's really just recognizing that the rule is there and that you have to think about applying it. So some of these slides are a bit dense. I apologize for that in advance, but they will provide you with the specific rule that is necessary to consider, and you want to think about how you can remember these particular rules. Hopefully you've remembered most of this from your MPRE exam and from professional responsibility, and hopefully this is all going to be a review process. So when we're looking at the attorney-client relationship, keep in mind that a lawyer has a fiduciary duty to a client. And this duty includes a duty of loyalty, a duty of confidentiality, of diligence, of communication, and of competence in representation. So one very important point to remember is the client really is in control. The client has hired you as a lawyer, and the client gets to make the major decisions. So the scope of our representation might be contractually limited with the client, but even so, there are certain decisions that the client has to be able to make. The client gets to decide whether to sue or settle, and our obligation as a lawyer is to make sure that we convey all offers to the client and give them the choice of whether to sue or to settle or to take the offer. The client also gets to decide whether to testify, whether to accept a plea, whether to request a jury or a bench trial, and whether to appeal. Now, we as attorneys get to provide information, but it is the client's ultimate decision on those issues, whether to sue, whether to settle, whether to testify, whether to accept a plea, whether to request a jury trial or a bench trial, and whether to appeal. Attorneys get to make procedural and tactical questions. What court, whether to take a deposition, what type of discovery to request, whether to request some sort of continuance. And there are exceptions where the attorney has to defer to the client. And sometimes those are exceptions to the attorney-made decisions. So if the client believes that taking a certain action that is an attorney's decision is too much money to proceed in that direction, then we have to abide by the client's decision regarding that. There are times that clients give us information, or we have some information about a client that may be troublesome, and it may be information that suggests that a client is going to engage in some sort of criminal or fraudulent conduct. If we have that type of situation, a lawyer must reveal client information to prevent a future crime, or to reveal a death that has already happened, or serious bodily harm that has happened, or, as always, if ordered by the court. Now, in certain circumstances, you may have some confidentiality requirements, but if you, as an attorney, take possession of or touch physical evidence, your obligation to the client regarding confidentiality no longer applies. However, if you view the physical evidence but don't touch it or take it, then you might then you still have the confidential relationship. So when we have clients who are indicating that they may be engaging in something that's criminal or fraudulent, we as an attorney have the obligation to talk about them, about why they shouldn't, about what will happen if they do, and to make some sort of determination of whether they should take that action or not. But we cannot assist the client in any way, and there are times when we actually do have to reveal that information to the court because it involves criminal or fraudulent conduct. We do have an obligation to keep clients informed. Remember, I said we have a duty of communication. Lawyers are required to keep in touch with their clients about the objectives and how those objectives are going to be accomplished, and to provide status reports, and certainly to provide information to the client when it is requested by the client. Now, an area that's tested very frequently is attorney's fees. So this is one area that we see a lot of issues come about. It's easy to drop an attorney's fees question into just about any other issue. So we have a limitation on our fees. We cannot charge clearly excessive fees that are considered overreaching or unconscionable. They must be reasonable. And we also can't secure a fee through misrepresentation or fraud, obviously. But otherwise, a fee agreement will be enforceable according to its terms. Those terms have to be reasonable. And reasonableness is determined by the amount of time and labor that's involved. It may also be determined by the novelty or the difficulty of the question, the legal question that's involved, and the amount of skill that's going to be necessary to resolve the issue. If taking one particular case will interfere with other employment by the lawyer, then that is a reason to have the fees be a bit more than they would be if the lawyer was also free to take on other work. Reasonableness is determined by looking at what's customary in the area for similar work. And if reasonableness is a concern, the court will look at the amount involved and the end result that was obtained, the length of the relationship between the parties, the experience and the reputation of the attorney, if there are time limits or circumstances that make something need to happen very quickly, that will be part of the reasonableness factor. And whether the fee is fixed or contingent is also usually considered as the court looks at whether fees are reasonable. When we represent a client, we must disclose to the client what our fees are going to be, and this should be done in writing, either right before or shortly after we agree to the representation. If any part of the legal fees are going to be non-refundable, that has to be in writing, and it has to explain why the fee is non-refundable and how much of the fee is non-refundable. So there are a variety of different types of fees that lawyers engage with clients about. So let's just make sure that we all are understanding the terminology that the Florida Bar uses for fees. A retainer is going to be an amount of money that a lawyer gets simply for being available in the future. It's not a payment for legal services, and it's either legal services that have happened in the past or that will happen in the future. It's simply a payment to keep the availability of the lawyer available for the client. So this is an amount of money that guarantees that this particular client can come to the lawyer and the lawyer will provide services. Some lawyers, for certain types of proceedings or certain types of matters, will charge a flat fee. It's a non-refundable amount of money that covers all of the legal services for a particular transaction. So sometimes a bankruptcy fee might be a flat fee. Some people do divorces on a flat fee basis. Title searches might be a flat fee. Something that is usually pretty routine. Usually it's an all or none type of thing. It's a pretty standard amount of hours, so both the attorney and the client understand right at the beginning how much is going to be involved here. There will be times that an attorney will ask for an advance, and this is money that the lawyer gets to charge against. So some people call this a retainer, even though it's not. This is an advance fee that the lawyer gets at the beginning of a proceeding or as they're about to engage in a pretty intense part of the proceeding, and it sits in the lawyer's trust account until the lawyer bills the client, and then when they bill the client, they pull this money out of the trust account that's already been paid there, so they don't have to worry about the collection aspect of it as the case is going on. Keep in mind that anytime any of these are going to be non-refundable, it has to be in writing and it has to be explained, and the explanation of why it is non-refundable is an important piece of that. Many lawyers, especially for personal injury cases or other types of tort cases, work on contingent fee bases. So a contingent fee is pretty heavily controlled by the rules of professional conduct. The rules set out detailed guidelines for contingent fees, and one of the most important things to remember here is that it is unethical and completely prohibited to engage in a situation where you've got a contingent fee for a family law case or for criminal cases. And there are guidelines in the rules about what types of percentages are allowed. We will look at the actual percentages in just a moment, but one thing to keep in mind is that if you charge a fee that's in excess of these guidelines, it's going to be presumed to be excessive. Now, that's a rebuttable presumption, but you must have a good reason for going beyond the guidelines. The fee amount may be tied to where the process of the case is as well. And we'll get into that in just a moment as well. But one thing that's really important, again, about contingent fees is, in addition to following the rules, they must be in writing, and the way that the fee is going to be determined has to be a part of that writing. So basically, in a contingent fee agreement, remember it has to be in writing. We have to have the client sign the agreement, and every lawyer who's going to be involved in the representation of that client also has to sign the agreement. These contingent fee agreements have to state the method of calculation. So, for instance, the different percentages that a lawyer will take in the event of settlement or trial or appeal. The fee agreement also has to include whether expenses related to the representation will be taken before or after the fee percentage is taken. And there must be a written closing statement that identifies the calculations and the final fee at the end of the agreement. Again, remember that fee agreements that are in excess of the guidelines will be presumed excessive. But that is a rebuttable presumption, so that there are times that may be an appropriate amount. It's rare, but it usually requires court approval. But it can, a fee agreement can exceed the recommended percentages. Contingent fees also have to include a particular statement of client's rights if they are contingent fees for personal injury cases or for product liability cases. The statement of client rights informs the client that they have the right to cancel the agreement within 3 days of signing it without owing any fees. However, they do have to pay reasonable expenses that the lawyer incurs during those 3 days. Now, most lawyers actually will avoid incurring any fees during that time while the client has the ability to back out of the agreement. The statement of client rights also must disclose the attorney's experience and education. Remember, this is for personal injury or product liability cases. It also must identify whether the attorney will handle the case by themselves or with other attorneys. It has to identify the client's right to get that closing statement that I mentioned earlier about how the fees are determined. And it must disclose the client's right to be kept informed at all times and the client's right to make all settlement decisions. Now, I mentioned that there are guidelines about the percentages, and these are the actual guidelines of the court, of the rules, and they are tied to both amounts of recovery and where we are in the process of a lawsuit. So contingent fees that are due because the case ends before an answer is filed are limited to 33 1/3% of any recovery up to $1 million, plus, if it goes over $1 million, 30% of the amount between $1 million and $2 million, And if it goes above 2 million, 20% of anything else. That's before an answer is filed. So that's at the very, very beginning. After the answer is filed, after a defendant files an answer, if the case settles, the attorney's fees are limited to, and not all attorneys will go this high, but they are limited to 40% of the first million, 30% of the portion between $1 million and $2 million, and 20% of anything over $2 million. If defendants admit their liability when they file their answers and request a trial only on damages, so they basically say, yes, we're going to settle this case, but we just don't agree on the amount, then we go to back to this limitation for the first million of 33 1/3, but the numbers for the amounts between 1 and 2 and above 2 drop down to 20% and 15%, because essentially there's less work involved in proving the case because the defendants are already admitting their liability. If a case goes to an appeal, an additional 5% can be added, or if there is some sort of post-judgment relief or action that's necessary to actually get recovery, then an attorney is allowed to add another 5%. One more piece that sometimes may come up in an essay question is that medical malpractice cases have different limits. In a medical malpractice case, the top contingency fee is $30,000 for the first $250,000 and 10% for anything over $250,000. So medical malpractice cases have a lower amount, a lower percentage. If a client is unable to obtain an attorney because of these limitations, the client actually can petition the court for approval of a different fee agreement. So the court can approve a higher agreement if it determines that the client really does understand all of their rights and they understand the terms of the proposed contract, but that they need to have the fee agreement be higher because maybe there's no other attorney available to do that type of work. Okay, moving on, let's talk about the duty of confidentiality. So generally, a lawyer can't reveal confidential information about a client unless they consent to him doing so. There are certain circumstances, as I mentioned earlier, where a lawyer has to break that confidentiality and must reveal the information if the client's going to commit a crime or if it's to prevent the death or substantial bodily harm of someone else. And there are times that confidential information may be revealed to actually establish a claim between the lawyer and the client, or to defend against the client's claim that the lawyer has committed malpractice. Keep in mind that confidentiality actually extends even beyond the death of the client. Okay, we also have a duty of loyalty to the client, and that requires that we think about conflicts of interest. Determining whether we have a conflict of interest is an important step even as we begin to think about whether we can accept a client, because a lawyer cannot undertake representation of one client if representing that client would be directly adverse to another client that the lawyer already has, or if there's a substantial risk that representing the client will materially limit the ability of a lawyer to represent another client in as complete a manner as they should. There are exceptions to this, and the exception would be if the lawyer has a reasonable belief that they have the ability to provide competent and diligent representation to each client, and these representations are not prohibited by law, and the representation doesn't involve asserting a position that's directly adverse to another client, and each client consents. So basically, we don't want to have clients that have interests that are at odds with each other, or a risk that will be limited in our representation of an existing client because of the potential for interests that will be at odds with another. But if we can find ways around that and both clients consent, then we can have that conflict waived. It's still not a great idea, but it's allowed. There are also times when we have a conflict based on our relationship. So if you are represented, if you are representing someone and the opposing counsel for that person is someone that's related to you by blood, adoption, or marriage, or to another lawyer as some sort of marital relationship or parent-child relationship, another lawyer in the firm, then we end up having an interest that is potentially directly adverse. The lawyer is directly adverse to the client's interest, and that would be a conflict of interest. So basically, let's look at what this actually says, because I probably have messed up the wording here. If a lawyer is related by blood, adoption, or marriage to another lawyer in the situation of being that lawyer's parent or child or sibling or spouse, they cannot represent a client in a representation directly adverse to a person who's represented by that parent, child, sibling, or spouse without the client's confirmed consent in writing and on the record at whatever hearing is going to be involved. So how does that play out in the potential exam issue? So you might have a situation where we've got Harry asking his new wife's son, who is a lawyer, to draft an amendment to a trust that's going to make the son the trustee and give him the power to choose the trust's beneficiaries when Harry dies. If the son drafts the amended trust and then upon Harry's death is asked by his mother to name her as a beneficiary, does the son have a conflict of interest? And the question should be answered yes, because there was a substantial risk that the son's personal interest in his mother's welfare would materially limit his representation of Harry. The son should have either declined to serve as Harry's attorney or disclosed the conflict and had Harry give informed written consent. Other ways that we might end up with conflicts between the attorney and the client involve business transactions. And here, lawyers are prevented from entering into business transactions with clients where they will acquire some sort of interest that is going to be adverse to the client, with the exception of a lien for attorney's fees or expenses. There are ways that this can happen. Again, that's the unless part here. If the transaction and the terms that are involved in the lawyer acquiring the interest are fair and reasonable and fully disclosed in writing, and the client is advised that they should get independent counsel about whether to engage in this transaction, and if being so advised, they still agree and give their informed consent in writing, then the lawyer representing the client is not a conflict. Another potential conflict is when a client provides a gift to the lawyer, and this often happens in a will, in a testamentary gift. And in that situation, the lawyer may have a conflict because if the lawyer is the person drafting the document that is actually giving the lawyer the gift, or a person related to the lawyer, some sort of gift, substantial gift, then that would be a conflict. Now, there is an exception to this. If the lawyer that's drafting the document is related to the person for whom they're drafting it, then that's not the conflict. We don't have a conflict in that situation. And by related, we're talking about if the lawyer is the spouse or the child or the grandchild or the parent or grandparent or other close relative of the client, then a gift in their will is not going to be a conflict. Basically, you want to remember that lawyers can't solicit or accept any gifts, especially in a testamentary situation, unless there's a close familiar relationship and or there's no preparation of the instrument that conveys that gift. A potential conflict arises too if a lawyer wants to provide some sort of financial assistance to a client. And often we have clients who run into some financial difficulties. The only type of financial assistance we can provide to a client is to either pay on their behalf or advance and then collect later court costs and expenses. Now, paying on their behalf is especially fairly common when someone is representing an indigent client and they can actually pay the costs and expenses of the litigation, but they cannot advance any other financial assistance to the client. There are times that we are representing a client and someone else wants to pay the bill. And that is perfectly allowed as long as the client gives informed consent for that to happen and the third party does not interfere with the lawyer's professional judgment or with the lawyer-client relationship. And as long as the lawyer keeps the client's information protected and confidential, regardless of who is paying. So third-party compensation is allowed only if the client gives informed consent, does not, and there's no interference with the independent or professional judgment of the lawyer, and the client's information is still protected. So another way that there might be a potential conflict is if the lawyer tries to take some sort of proprietary interest in the cause of action. So the lawyer can't take on a cause of action and say, I'm going to be included in part of the recovery beyond the fee. The only type of ownership interest in the cause of action might be a lien to secure the lawyer's fee and expenses, or a contract with the client for the reasonable contingent fee. Conflicts also arise when we have former clients. So even though the client is no longer a client, we have to think about whether that particular client may cause a conflict with new clients. So former clients involve us thinking about whether we can consent to new client representation where the new client's interests are materially adverse to the former client's interest, or the other way around. And if that's the case, the lawyer cannot use information gained from the former client to the detriment or benefit of the new client, unless that information is generally known to the public. So if a lawyer learns something about a former client through the representation of that client that is not general public knowledge, and then finds a new client who would benefit or would be harmed by that potential information, that presents a conflict based on the former client. So if we've got lawyers in a law firm, you have to keep in mind that generally, if one lawyer is disqualified, the entire law firm is disqualified from representing a client because of a conflict. The only exceptions to this is where the disqualification of one lawyer is not going to disqualify the entire firm because the disqualification is based on the lawyer being a family member of the opposing counsel, or if we have in the firm a newly associated ex-government lawyer or ex-judge whose disqualification is based on their former job with the government, and they are somehow timely screened from the case and don't get to share in the fee. And finally, one way that the firm is not disqualified is if the lawyer's disqualification is because of personal interests, such as political beliefs or some other personal interest that prevents the lawyer from handling the case. So the rule basically sets out that all lawyers in the firm are disqualified if one of them is. And when you bring in a new lawyer, you can't represent someone who has a potential conflict against